Today is our second class on torts. The topics which we will cover today are defamation and its related torts and product liability. Beginning with defamation and its related torts, the three torts which more or less go together are defamation, invasion of privacy, and intentional infliction of emotional distress. These torts are so related that if you have something to say about one of them, please look for an opportunity to say something about the other two, even if it's nothing more than explaining why they're not there. Now, defamation is, of course, defined here, and it's a false statement that that injures the plaintiff's reputation. False light, of course, harms the person's reputation. And intentional infliction of emotional distress, you can see that if you made a statement that injures someone's reputation, that you can make an argument that a person intended to inflict severe emotional distress. Maybe they didn't succeed, but you can see that you need to say something about it. And so, defamation, false light version of invasion of privacy, and intentional infliction of emotional distress kind of go together. If you say something about one, mention the other two. Our lesson primarily today is about defamation because it is the most complicated of these. The others are fairly straightforward. Definition of defamation is a good place to begin, and here it is. Defamation has a number of parts to the definition, and I encourage you to clearly memorize this so you can spit out these parts. Defamation is defined as the false and defamatory statement. There are some rules about whether or not the statement, what do you presume it's false, or does the plaintiff have to prove it's false? Defamatory has a definition, holding the person up to scorn, ridicule, contempt. Material fact is self-explanatory. Concerning the plaintiff, this is where if the statement is made about a group, does that still concern the plaintiff? Suppose you don't name the plaintiff, is it still concerning the plaintiff? So that element needs to be there. False, defamatory, material fact, concerning the plaintiff, understood in the defamatory sense. This is what the innuendo is about, so that a person might not understand a statement in the defamatory sense if it has more than one meaning. And the general rule is that if a reasonable person might interpret it in its defamatory sense, then that's enough. And finally, causing harm to the plaintiff. The harm can be harm to the plaintiff's reputation, or it can be economic harm. So let's go through these elements again to get the broad idea of what is covered. False statement. At common law, there was a presumption that a defamatory statement was false. And you need to know that. However, modernly, if we're looking at the constitutional issues, that is, if we are defaming a public figure or defaming a public official, or if the matter is about a matter of public concern. We'll go through these more carefully, but I want to lay out the basic plot. That in those cases, public figure, public official, matter of public concern, that the falsity is no longer presumed as it was at common law. The plaintiff has to prove that the statement was false. Defamatory statement, definition of what is defamatory, old definition, holds the plaintiff up to scorn, ridicule, contempt. Modernly, we say if the statement lowers the esteem of the plaintiff in the eyes of the respectable members of the community. So the statement needs to be defamatory in that sense. A material fact is self-explanatory. Concerning the plaintiff, once again, if the plaintiff is literally named Senator Hillary Clinton and you try to defame her, clearly it is concerning the plaintiff. But suppose you said that female senator from New York, so you haven't really named her. Is that still concerning the plaintiff? What is the rule that deals with that? Suppose it's group defamation. That is, you say, you know, all the employees of Macy's are, and then say something defamatory about them. Well, is that group so large? How about all of Mrs. Jones' sons are murderers? And she's got 3 sons. And so when you have group defamation, there's a rule about how to decide whether or not an individual member of the group can sue. Understood in the defamatory sense, okay, this is what innuendo is about, if it can be understood in more than one way. Causing harm can be economic or reputational harm. So that's the definition of defamation. And we are going to work this definition in much more detail and apply it to particular problems that were on the bar exam in the past. Invasion of privacy, you know that there are these 4 forms of invasion of privacy. False light, and if you hold someone up in false light, it must be highly offensive false light. The classical example given in Gilbert's, for example, is the case of a politician who was in fact walking in front of an American Nazi Party flag. Now, his reason for being there might very well have been noble, but a picture was taken of this political figure in front of the flag, and this was published, and it turns out that that was in false light. He was not there to advance their cause. And so that's holding the person up in false light in a manner that is highly offensive. These false light cases, what is being presented is in fact true, because the politician was in fact in front of that flag, but it was used to portray the person in a false light. The second form of invasion of privacy, intrusion into one's seclusion. One might trespass onto land and look through the keyhole and intrude into one's seclusion, but you can also do it without trespass. A person will use a very high-powered telescope from very far away to look into one's bathroom or bedroom or something. That would be intrusion into one's seclusion. Public disclosure of private facts. These private facts which are publicly disclosed must be private facts which are highly offensive, or very personal at least. And finally, appropriation of one's likeness occurs where someone makes commercial use of your likeness, and you can sue either for the commercial value or to try to find some other basis. If it's a public figure, then appropriation of the likeness already has a pecuniary value, monetary value. But if it's a non-public figure and they appropriate your likeness, now it's harder to find a public value for it, but you do the best you can by pointing out that if they had come to you, to this individual, the non-public figure, to ask them to model for this, what's the modeling value worth? So, and then finally comes the intentional infliction of severe emotional distress, which has its elements, namely that the person acted in an extreme and outrageous manner. Extreme and outrageous conduct which was intended to inflict severe emotional distress. So these three torts go together: defamation, invasion of privacy, intentional infliction of severe emotional distress. We're going to spend most of our time today on defamation because by far it is the more complicated of these three torts. So let's look at the issues of defamation. Defamation has a definition, and here it is. We've gone through the definition, but if you're going to do an analysis of a defamation question, here are the separate parts that you would analyze. One, was it a defamatory statement concerning the plaintiff? Two, was it publication? Three, was the plaintiff damaged? 4, are any defenses applicable except for the constitutional defenses? Are any of the common law defenses applicable? And 5, the constitutional defenses. So we have 5 parts to the analysis of a defamation question, and those 5 parts are the ones shown here. Now I realize there's a lot of material on the board, and I will go through it quite slowly so you can copy it down as we go through it, rather than feeling that you must copy it all down quickly. So as I go through, you might make notes at that time, rather than so you can concentrate on what's going on. First, was there a defamatory statement concerning the plaintiff? So we have 2 parts. Was the statement defamatory? And was it concerning the plaintiff? On the first question, was the statement defamatory, we need a definition of what is defamatory. The definition, as I mentioned to you, there is the older and the newer definition. You may use either. The older definition was the statement held the defendant or the plaintiff up to scorn, ridicule, contempt. The newer is that the statement lowers the esteem of the plaintiff in the eyes of the respectable members of the community. So with that definition of defamation, we have a couple of wrinkles that we need to comment on, to expand on that. One is inducement, the other is innuendo. Now, the case of inducement is the case where the person makes a statement, but you need additional information in order to recognize the statement as defamatory. Classical example given in a lot of textbooks, and it's an old example, but it makes the point. A long time ago, someone said, Mrs. Jones just had a baby. Well, if you knew that Mrs. Jones just got married a month ago, then that means that she got pregnant before marriage. And if you go back far enough where that was considered very defamatory, then this would be a defamatory statement about Mrs. Jones. But you wouldn't understand it as defamatory unless you knew that Mrs. Jones just got married a month ago. And so in the pleadings, where assuming that the statement that Mrs. Jones just had a baby was false, and now you have a false statement, well, in order for it to be defamatory, to hold her up to scorn, ridicule, contempt, to lower her esteem, you have to know that this defamatory, the statement she just got married a month ago, she just had a baby, you'd have to know that she just got married a month ago. And so that additional statement that you have to know in order to understand the defamatory sense is called the inducement. It's not the statement itself so much that is called the inducement. It's more that at common law, when you made a cause of action for defamation, the pleadings themselves had these different parts to it. And one part of the pleading was called the colloquium. And that's the part where if the defendant was not, the plaintiff, if the plaintiff was not specifically named Mrs. Hillary Clinton, if the plaintiff was not specifically named, then in the colloquium part of the pleading, you had to explain why people knew that this statement was about Hillary Clinton. That female senator from New York said so-and-so or did so-and-so. And so everyone knows who that is, but you have the colloquium as the part of the pleading where you would explain why people knew that the defamatory statement was about Mrs. Clinton. That's the colloquium. The inducement is another part of the pleading. The inducement is the part of the pleading where you explain that there were people out there who knew that Mrs. Jones just got married last month. So the inducement is needed in those cases where an additional fact is needed to make it defamatory. Innuendo is where you explain that although the statement has an innocent and a defamatory meaning, that there are a number of people out there who would have taken it in its defamatory sense. You don't need everybody, but if somebody, one person even, would have taken the statement in its defamatory sense, then the innuendo is satisfied. So in order for the statement to be defamatory, here is the definition. You may need to show that people knew some additional fact, and you may need to argue that some people would have interpreted this in a defamatory sense. Next, the defamatory statement must be concerning the plaintiff. Now, concerning the plaintiff, we have three possibilities actually. One is that the plaintiff was named Ms. Hillary Clinton in my example. In that case, you don't have a problem that the defamatory statement was concerning the plaintiff. But if the person is described without their name, then again, the colloquium is the part of the common law pleading where you made your explanation that people knew who the defendant was talking about. Group defamation occurs where you defame a whole group of people, and if the group is too large, of course, no one member of the group can recover. All surgeons are butchers. Well, no one surgeon could recover from that. On the other hand, if you named a particular medical group, the Jones Medical Group got a bunch of butcher surgeons, and there's only a half a dozen surgeons in that group, that is probably enough so that a reasonable person would think that any one member of that group was a butcher. So if the group is small enough that a reasonable person would believe that it applied to a particular member, that member can sue. So the group needs to be fairly small, but there's no fixed number. So our first part then of a cause of action for defamation is that the defamatory statement concerning the plaintiff, here's what you may need to say about the defamatory statement, here are the things you may need to say about it concerning the plaintiff. That brings us to the second element of defamation, and the second element is, was the statement published? Now, the requirement for publication, of course, is that it has to be disclosed to a third party, someone other than the plaintiff. The requirement is that there must have been intent to publish, not necessarily intent to harm. just intent to publish the statement. This means that, for example, if one dictates the statement to one's secretary to have it typed, that statement there was an intent to publish to a third person. If you send, as often given in the textbooks, if you send a written statement to a blind person, you know that somebody else is going to read it to them. So that's intent to publish. Next is the case of the republisher. Now, the republisher is a person who receives the information and tells somebody else. And so if you tell me something defamatory about Joe, and now I tell Mary about it, I am a republisher. And the rule is that the republisher is just as liable as the original publisher. It also is true that if the publisher has a defense, that the republisher cannot use that defense. For example, if you are a member of Congress and you make a statement on the floor of the House of Representatives or the Senate, you are completely immune from suit for defamation. You can say anything you want to in those circumstances, and you're immune from suit. So if you defame someone while in that setting, and the person sues you, you have a complete defense. But if I heard you say it, and now I republish it to someone else, I cannot use your defense. I have to have my own defenses. And if I don't have one, I may be in trouble. One of the famous defenses that comes about that way is the so-called record libel defense. So if you are on the floor of the House of Representatives and you make a statement, it ends up in the congressional record. And now that that statement is in the congressional record, if you now publish what the congressional record says, well, you may be defaming someone. And that's why you need that special defense, the so-called record libel defense, because you can republish what's in the congressional record without being liable for libel. Republishers, now, not only is the republisher liable for whatever the republisher said, but the republisher, the original defamatory person who made the original defamatory statement, is also liable for what the republisher did if the republication was foreseeable. So if I call a press conference and the people at the press conference now put it in their newspapers, that republication, I published first, I told them they put it in their newspaper, that republication is foreseeable. So I am liable for the republication. If I dictate to my secretary and it is foreseeable that this is going to be republished, so the original publisher is liable for the republication if the republication was foreseeable. And also I might mention that if I orally make a statement to the news reporters, and that's slander, but then the news reporters put it in print, and so now it's liable. Am I liable only for my original slander, or am I liable for the libel? If I tell my secretary and it ends up being typed, am I liable for the libel or the oral slander? And of course the answer is that it depends on whether or not the written republication was foreseeable. And here it's quite foreseeable in both of the examples I gave you that it was going to be republished in print, so I am liable for the libel. Next, under publication comes the disseminators. Now the disseminators generally are people such as newspaper sellers. And so if you have you're selling newspapers on the corner, you are further disseminating the defamatory statement. But the rule is that these disseminators, of course, are not liable unless they know and that the statement is defamatory and they're purposely further disseminating it, but just selling a newspaper, this never gets tested because the rules are kind of fuzzy. But the general rule is that the disseminator is not liable unless they know about the defamation. And even if they know about the defamation, if you are a newspaper seller and you know that something in the newspaper is defamatory, I don't think you have to stop selling the newspapers. I think you have to, it's going to take more than that, and we don't really have any good cases on that. So we now have two of these elements that we have dealt with, 1 and 2. Element 1, you need a defamatory statement concerning the plaintiff, and the two parts to that have been dealt with here. Secondly, you need publication. That means intent to publish. We know about the issues regarding the republisher, that the original publisher is liable for the republication if it was foreseeable, and the republisher is liable for their own defamation. Disseminators, like newspaper sellers, they're not liable unless they know they're very unlikely to be tested. This brings us to part 3, damages. Now, the person who is injured by the defamation can be damaged by simply the loss of their reputation. Reputations have value. Your credit rating, for example, your credit worthiness, not this modern formula or something, but just generally your credit worthiness is valuable to you. And so a person might be injured by damage to their reputation, lowering their esteem in the community, but the person also might incur economic loss, so-called pecuniary loss, because of the defamation. If I was about to get the part of Jesus Christ Superstar in a movie that's about to be made, and someone defames me in such a way that it is no longer believable for me to be that person in the movie, and I lose my opportunity, well, that's an economic loss. And you can think of various other ways that the damage to my reputation may result in an economic loss. And so my losses might be loss of reputation, and there may be economic loss. And we need to know when you can recover for each of these. So let's begin with a case. We have to distinguish, to deal with that, we need to distinguish between statements which are libel and those which are slander. A libel statement, we need a definition first of all. A statement is libel if it is in print. But we also include more than just print. Originally, of course, it was just print because that's all there was, either oral or print. But now information can be disseminated in other ways, over the internet, television, radio. And so, excuse me, the definition of what is libel now really has sort of moved towards how, looking at how broadly is the statement disseminated. And if you disseminate it over television, that's such a broad distribution that will probably be treated as libel, and the same thing with radio, probably be treated as libel because of the breadth of the definition of the distribution. Certainly, if the person is reading from a transcript, then it's already libel, and the republication will continue to be libel. But if it is the person is ad-libbing on the radio or TV and is broadcast that widely, make your argument, explain the public policy, and that would probably be treated as libel just because of that. Historically, the idea was that if information is in print, that it will probably get distributed more widely, and it would last longer, because things in print last a lot longer than simply things which are orally said. And so if the statement is distributed more broadly and it's going to last longer, and the printed material especially would last longer, that's the reason for going to libel. Whereas modernly we use the same concept, but obviously television internet and so forth serve the same purpose, make the argument. If the statement, if you decide it is libel, then we still have two types of libel that you must distinguish between. Libel per se and libel per quod. What is the difference? Libel per se is a libelous statement that is in print, for example, which is libel and it does not require, that is libel per se, does not require any of those helpers that we talked about. Doesn't require colloquium to understand who the plaintiff is. It doesn't require inducement, that is some additional fact to understand that the statement is defamatory. It doesn't require innuendo interpretation of what the statement means in order to understand it in a defamatory sense. So a libel per se statement is a statement which is written, or as I mentioned on TV or some other internet or some other broad distribution. So if it's libel per se is in that broad distribution form and does not require colloquium to identify the plaintiff or inducement or innuendo. That is libel per se. And the reason we care about whether or not something is libel per se is that it relates to the damages. When a statement is libelous per se, there is a presumption that the person has lost reputation, that their reputation has been damaged. There's no presumption as to the amount of loss of reputation, but there's a presumption that as to the existence of the loss of reputation. And since you now have a presumption that this particular damage exists, this allows you to stay in court because the element of damages is presumed to exist. You can see the problem that if you're looking at someone at a fuzzy kind of damage, like someone's loss of reputation, well, that's so fuzzy that if you must have damages in order to stay in court, because you need to make out each element of the prima facie case, and damages is one of the elements, and all you've got is loss of reputation, you can see you've got a problem. But we solve that problem by saying, if it's libel per se, then the legal system presumes the existence of the loss of reputation. And you still, of course, have to go before the jury and make your argument as to how much reputation was lost. But at least you don't get thrown out of court because of the lack of damages, because it's presumed to exist in the libel per se case. Now, if we go to the libel per quod, the libel per quod case is the case where you do have the writing. You have the writing, or you have some other kind of broad dissemination, such as internet, TV, radio. You have that, but you need one of these helpers. You need colloquium or innuendo or inducement in order to make out your case. Well, this is in print, or the equivalent of that nowadays, but it's not quite as bad as the libel per se, because a lot of people won't know that additional information. A lot of people won't make out the help. The helpers won't be there for a lot of people. And so, in the case of libel per quod, should you presume the existence of loss of reputation in that case, presume those damages, or not presume those damages in the case of libel per quod? Okay, and the answer is there's a three-way split of authority as to whether or not you should presume the existence of loss of reputation. Some jurisdictions say yes, go right ahead and presume it, just as though it was libel per se. Other jurisdictions say no, don't do it because the injury is too indirect, so don't presume the existence of a loss of reputation. And the third jurisdiction is there's a yes and no, and the in-between, of course, yes, no, and maybe. The maybe one, the in-between one, says we will presume the existence of loss of reputation if the libel per quod is about a subject that would have been slander per se if it had been slander. Now, we haven't talked about slander yet, but you know that there are 4 circumstances under which there is slander per se, and where there is slander per se, there is in that case also a presumed loss of reputation, presumed to exist. And pardon me, I'm sorry, I said that wrong. Strike that statement. Where there is slander per se, you can see the general rule. I need to explain 2 or 3 things here. I'll have to do them to make sense of it. In the case of libel, let's take the case when there is libel. If there is libel per se, or if you're in certain jurisdictions for libel per quad, there is a presumption of loss of reputation. And in those cases, you can recover for the loss of reputation even if there were no monetary damages associated with it. If you couldn't prove that you lost money or some business opportunity, the only thing you lost was some of your reputation. Well, in these cases here, you can still recover for that without monetary loss if you have libel per se or if you have libel per quad and you're in the right jurisdiction. Whereas, in the case of slander, the rule is that if there is slander, you can recover for slander only if you can prove pecuniary loss. Proving loss of reputation by itself will not work. You get thrown out of court. So in the case of oral defamation, in case of slander, that you have to prove money loss or property loss, pecuniary loss, money or something that's the equivalent of money. So you have to prove pecuniary loss in the case of slander, and then if you can prove the pecuniary loss, now you can also recover for your loss of reputation. Let me give an example. So if I am, again, about to receive the star role in Jesus Christ Superstar, and because of someone's slander, I am rejected for the part. Now I have monetary loss, and so I can recover for my monetary loss, and I can tack on to that whatever reputation loss I can establish and collect for that also. But I can't even, seriously, the court won't even consider my reputation loss unless I first prove the pecuniary or money loss in the case of slander. And the exception to this is the case of slander per se. I have it sort of briefly indicated here, but these are special damages, and the exception, I don't have room to put it here, but what I'm trying to explain is that in the case of, you need special damages in the case of slander in order to stay in court at all. But there is an exception. I'll put it here, EXC for the exception, and there are 4 exceptions where I don't have to prove monetary damages and I can still collect for slander. And those are the 4 slander per se cases. Slander per se exists where where the oral statement defames the person about claiming the person has committed some crime of moral turpitude, claiming that a woman was sexually promiscuous, claiming that a man was sexually impotent, and defaming a person in their profession. So you call a doctor a butcher, you call a woman a prostitute, you call say a man is impotent, can't have sex, and if you say that a person has committed some crime of moral turpitude, robbed a bank, he's a thief, and so forth. In those 4 cases, those are called slander per se cases. And in those cases where the slander is slander per se, you can recover for pure reputation, even if you don't have money loss. You can recover for pure reputation loss if it's slander per se. If it's slander but it is not slander per se, then the only way you can stay in court is to prove money loss. And if you can prove money or property pecuniary loss, if you can prove that, then you can collect the money loss, but you can tack on to that any loss of reputation if you can prove the loss of reputation. So that's how slander works. Let me run through this one more time because we're going to use it up here. Slander is oral defamation. Slander, ordinarily, you must prove special damages to stay in court. Special damages means money loss or pecuniary loss. If you don't prove that, you get thrown out right away. The exception to that is if the slander is about one of those four special topics, and if that's the case, then you have slander per se, and you can collect for pure reputation loss without any money damages. Now, going back to libel, we understand that libel per se is when you don't need any of the helpers. You don't need inducement, innuendo, or colloquium. That's libel per se. And libel per quad is where you need one or more of those helpers in libel per quad. And there's a three-way split of authority as to whether or not there is a presumed damage of loss of reputation. Some say yes, some say no, some say if the libel per quad is about one of these four subjects that would have been slander per se if it had been slander. Again, the middle road here is if the libel per quad is about one of the four subjects that would have been slander per se if the statement had been slander, then loss of reputation will be presumed. Otherwise it won't. So three views on the libel per quad on the question of will reputation damages be presumed? Yes, no, and the in-between. So that takes care of the elements so far, the first three elements. These are defamatory statement concerning the plaintiff. It has two parts. Was it defamatory? Was it concerning the plaintiff? The publication of that statement. You need intent to publish. Don't forget about republishers. And damages. If it's libel, there's a presumption of the existence of loss of reputation. And, of course, if you have monetary damages, you can tack that on also. If you have libel, but let's say you have libel per se. If you have libel per se, there's a presumption of loss of reputation. But if you can also prove money loss, you can collect that too. Libel per quad, we know about the three-way split. And finally, slander. For slander, you need money loss in order to stay in court, with the exception of the four cases of slander per se. Now, we go then to the fourth element of defamation, and the fourth element is here, are the defenses. Now, the defenses are the privileges, absolute privilege and the qualified privilege. As I mentioned to you, the absolute privileges are those privileges such as the discussion with one's spouse, absolute privilege, statements on the floor of any of the houses of Congress, absolutely privileged. Sometimes what people say in court, some authors label that as absolutely privileged, but they always then go on to explain that even if it's absolutely privileged, that the statement that the person made in court must be somehow related to the cause of action. So if you are in court and you're testifying regarding a contract case, and you make some statement regarding the contract case that makes some statement has nothing to do with the contract case, but is a defamatory statement. It's just you use this opportunity to defame somebody. That is not going to be privileged. So even though sometimes we speak of statements by witnesses in court as being absolutely privileged, they need to have something to do with the cause of action, or it will not be absolutely privileged. Then finally comes the qualified privileges. These are the cases where you think that a professor in law school is giving grades for sex, and you publish that in the newspaper. Well, that is going too far. If you think that's true, you should go to the dean or someone who's an authority to deal with that, as opposed to just publishing it far beyond what is needed in order to protect the interest that you're trying to protect. Now, and of course, if one has a mere qualified privilege and goes too far, you lose the privilege altogether. There are also, other privileges such as the privilege of to protect your own interest or to protect the interest of close relatives. Your sister, as this is an example given in several textbooks, is going out with someone, and you tell your sister you believe that person is an ex-felon. Well, if the person is not, you have an interest in protecting your sister's interest, and even if it turns out to be false, that's a qualified privilege, and if you don't disseminate it any further than that, that's perfectly okay. Likewise, if someone defames you, you can defame back. You can say things in protection of your own interest, and those will be qualified privileges. Finally, we come to the fifth category of defamation, and those are the constitutional defenses. Now, the constitutional defenses, there are three things we are concerned about here. One is that at common law, there was a presumption that if I made a defamatory statement about you, at common law, if I made a defamatory statement about you, it was presumed to be false. The presumption was that no one, would do such an awful thing as what I just said about you. And so there's a presumption that the statement was false at common law. Any horrible defamatory statement I made about you was presumed to be false. Well, that's interesting, and it still works in common law cases, but you can see how you don't want to apply that rule when you're talking about political figures, for example. You're talking about any public official. You want people to be able to speak freely about public officials. And if you say something and get it wrong, then that's one thing. But if you say something and the presumption, you say something derogatory about a political figure, and that's presumed to be false, well, that political figure who now sues you has got the benefit of a presumption that the statement that you made, the non-flattering statement you made about this political figure is presumed to be false, and now you got to prove it's true. Well, that would, injure your free speech substantially. And so when, modernly, if we're talking about public figures, public officials, or matters of public concern, we eliminate that presumption. So there is no common law presumption of falsity if the statement is about a public figure or public officials or a matter of public concern. The person has to prove it's false. Secondly, when we come back from our break, we want to look at the rules when you do say something derogatory about a public figure or public officials. When can they sue? And the answer is under very limited circumstances, because you obviously want people to be able to speak freely about their public officials. And so there are very limited circumstances where the public officials or public figures can sue. And finally, if you are speaking about a matter of public concern, you believe that Joe has smallpox. Smallpox is, that's a matter of public concern. You think that anything where the public has an interest in that you want people to speak fairly freely about matters of public concern, even if they're wrong. You want them to be able to speak out about them. And so in the case of speaking out against a public figure or against a person in a matter of public concern, we want people to be able to speak more freely without getting sued, and that's what these rules are about. So we want to complete this analysis and then look at some real questions. Let's take 10.